Okay. Hello, everyone. Thanks for joining today's webinar. Um, my name is Sanjoy De. Those of you who do not know me, I live in San Diego, California, and my company's name is Corfu Capital, and I formed it back in June 2022. It's like a real estate venture capital company. We invest in states, sunbelt regions like in Texas and Arizona, and my company helps investors to earn passive income and grow generational wealth through multifamily investment. So anyway, so today we'll go over estate planning with a good friend of mine, Natalie. Natalie agreed to actually give us time today. She lives in Southern California as well, and she's been working as a lawyer for about 18 years. And when I actually talk to my investors regarding, real estate investment or so, estate planning is a very common item that pops up. And I noticed that many people are concerned about it. They have no clear idea that what they need to do, how to protect their legacy, and how to, you know, um, how to know the other like nitty-gritty stuff that they need to know. So that's why I thought that Natalie, who is a subject expert, she could give us some good advices and good knowledge. She could share. So Natalie, the floor is now yours. Please walk us through.
Great. Thank you so much for having me today, Sanjoy. Let
Sure.
me go ahead and share my screen. Can everyone see that?
Yes. Yes, we can.
Okay, wonderful, wonderful. So hello, everyone. Welcome to the webinar tonight, Estate Planning 101. Thank you again, Sanjoy, for having me. I'm Natalie Teramoto of Terra Legacy Planning. I'm really excited to be sharing with all of you today. I really think you're going to learn a lot, and this is going to be a great use of your time. So I really appreciate everyone coming on at 5 o'clock on Friday. You're really going to learn a lot, and I'm excited to kind of walk you through everything. So for the next hour, I'm going to be sharing with you basically the basics and foundation of estate planning. So my goal with this webinar is to leave you with a better understanding of what estate planning is, how it benefits you and your family, and what happens when you don't have an estate plan so that you can make educated, informed decisions about what is best for you and your family. So the format of the webinar today will very much be like a personal consultation. Again, my goal is to educate you and just to explain the different options that are available. So by the end of the webinar, you really should have a good idea of what is right for you. So I know some of you may be parents of minor children and you want to make sure that your kids are going to be taken care of by the people that you want, how you want, should something happen to you. So we're going to talk a little bit about that. We're going to talk about probate court, how you can avoid it. If you don't know what probate court is, don't worry. We're going to go over all of that. And then we're also going to talk about how you can make sure your kids don't lose their entire inheritance in a divorce, and how to make sure that they don't get huge check on their 18th birthday. So I know these things are important to parents, and we're going to talk about how we can prevent things like that from happening. So my plan is to speak for about 45 minutes or so. I do have a special gift at the end, so please stay until the end if you're able. And then we're going to have time for some questions and answers as well. So before we start, I just want to remind everyone that all the information I'm presenting today is purely for informational and educational purposes only. I'm not giving anyone specific legal advice as everyone's situation is different and I don't know what your specific set of facts are or what your situation is. All right. So everyone is in the right place tonight. If you know you need an estate plan, you're just not sure where to start. You're wondering what your options are, what happens if you don't have a plan. You're wondering what the process looks like, what's involved. So if any of this resonates, if you have any of these questions, you guys are in the right place and we can go ahead and dive in. So before we get started, I do want to quickly tell you about myself. Again, I'm Natalie Teramoto. I graduated from Chapman University School of Law in Orange, right here in Orange County. That is where I am based. I have over 18 years of legal experience. I was an in-house attorney for First American Title Corporation for several years doing corporate real estate and insurance law before going out on my own. Again, I'm licensed in California, so I serve all California residents in both Northern and Southern California. I'm especially passionate about building generational wealth and protecting it through estate planning. So I actually lost my dad unexpectedly 7 years ago. And I was so grateful to him that he had his estate plan in place, making it very easy for me to carry out his legacy exactly as he wished. And I realized then how crucial having a properly planned estate plan is to preserving a family's legacy and to helping to minimize stress during a very difficult time. So this is really what inspired me to help others build, plan, and protect their family legacy, ultimately leading to the launch of Terra Legacy Planning. I am a mom to two active young boys. I love spending time with my family, planning trips, and making memories. I strive for excellence and I value relationships and transparency. So here is a photo of my family, my two boys and my husband. So at the end of the day, when we talk about estate planning, the big picture is that it's not about you, it's about the people that you love the most. So with that said, during the presentation today, while you're learning about estate planning, I want to remind you, I'm asking you if you can think about the people in your life that you love the most, because I'm sure that they're the reason why you're here today to learn. So I want to start with some common objections that I hear a lot about estate planning. And some of those are my spouse is just going to take over, so why does it even matter? I'm too young to need a will, or I hear a lot of, I don't have any money, I don't need it. So as we go through today's presentation, I think that you'll all see how estate planning can help and that it's not just for older folks or those that are wealthy. Really, no matter your age or how much money you have, it ensures your assets, no matter how big or small, are handled according to your wishes. So another common misconception that we're going to talk about today that I hear about estate planning is that estate planning is only for death. However, estate planning is also planning for unexpected incapacity. There's a lot of statistics out there that basically say that most of us will become disabled at some point in our life, and we're going to need some form of care, and we're going to need to designate someone to make those financial and health decisions on our behalf. And many people have no plan in place for when this happens. So what is estate planning? Estate planning is really just about protecting your loved ones from the unnecessary stress, confusion, and financial strain in the event of incapacity or passing. It's pretty much just making sure that you don't leave a huge mess for your loved ones to clean up after you're gone. Like I mentioned earlier, I realized how much of a gift this was when my dad passed away unexpectedly. It was a very difficult time for the family, but we were all very comforted by the fact that he had a plan in place, which really helped to minimize stress. And we were able to follow the instructions that he left behind. So these are some of the things that estate planning accomplishes. I'm going to go through each quickly because we're going to address most of them during the webinar with more examples. But I want you to think about which of these are important to you. So estate planning is being able to give what you have to whom you want, how you want, when you want. It's about caring for yourself during your lifetime in the event of incapacity. It's about caring for your spouse, your children, your pets, avoiding probate court, and we're going to talk more about that. Fulfilling charitable intentions. So if you had, your favorite foundations or charities that you wanted to gift to, it's about being able to do that. Sorry, I have the sun coming in right now, but I hope you guys don't mind. Um, it's about maximizing the value of your assets distributed to your loved ones, and it's about minimizing your taxes at death. We all don't like to pay more tax than we need to. And then it's also about protecting your assets from creditors, divorce. Ultimately, what it really is giving peace of mind, offering peace of mind that everything is taken care of the way that you intended. So I want you to ask yourself a few key questions about the future. Can you predict the next 40 years of your life or your family's life? Do you know how healthy you're going to be in 10 years? Would your family be protected if you were no longer able to take care of them? So these aren't intended to be trick questions, but how many of you guys know none of us are able to really answer these questions? They're all tough and we don't have the answers. But I think that's what highlights why estate planning is so important, so that no matter what happens, we have the peace of mind that our loved ones are being taken care of. So in the next couple slides, I'm going to go over a couple examples of how having an estate plan can be a benefit. So scenario one, we have Sarah, who is aged 65, and she falls ill unexpectedly and requires hospitalization. With a comprehensive healthcare directive in place, her family knows her wishes and can make decisions confidently. So this is an example of incapacity planning. So Sarah hasn't passed away, but she's fallen ill and isn't able to make decisions or on her own or communicate her wishes. But because Sarah has this healthcare directive in place, her family is able to refer to that and confidently make decisions when she's unable to do so herself. So some of the benefits of having a healthcare directive: you get to express your wishes. So basically, you can state your preferences for medical care, including the treatments you want or you don't want, especially important in emergencies or near the end of your life. You're able to name a healthcare agent. So that just means designating someone to make those healthcare decisions for you when you're unable to do so. Another benefit of having it is it avoids confusion or disagreement about your choices. It relieves the caregivers of the burden of making those tough decisions. Oftentimes, in those situations, we don't really know what that person might have wanted, what our loved one wanted. And so this makes it very clear what their decision would be and the decision that they would want you to make on their behalf. And then it also ensures that you get the care that you want and you get to plan ahead to make sure it's the medical care that you chose. So all of these things highlight the benefit of having a good estate plan in place. Our second example is Michael, who's age 70. He passes away peacefully, leaving behind a detailed will that clearly outlines the distribution of his assets. So his family, grieving the loss, finds solace in the fact that his final wishes are being honored. So this is a great example of the family not having to second guess what Michael's wishes were. He left a very detailed will that clearly outlines where he wants all his stuff to go and to who. So these scenarios highlight how estate planning can be a gift to your loved ones during challenging times. So pictured here is my dog Barney. He's 15 years old. He looks exactly the same as in this picture. He was my first baby, and so I'm using him to highlight that estate planning isn't just about finances, You can also make sure that your pets are taken care of too. So if you have a family pet, you're going to want to make sure that they're provided for, and you can do that by having a pet trust as part of your estate plan as well. And then some of those other benefits we briefly mentioned earlier, and we'll continue to talk about them throughout the rest of the presentation. So what do we even mean when we say estate? So many of us, I think, we don't think that we have an estate. We kind of think maybe only really wealthy people have an estate, but we all have some of these assets or accounts. We all have a bank account, I'm sure, checking, savings, car, we have a brokerage account, we may have stocks and bonds, life insurance proceeds, if we own a home, if we own investment property or rental homes, those of course are included in an estate. Your retirement accounts, IRS, 401ks, any personal coin collections or jewelry, intellectual property, and then if you have any business interests, those are all going to make up your estate. So with all this stuff, we need to decide where all of it's going to go when we pass away and under what circumstances. So we've gone over a couple examples of good estate planning, and in the next few slides, I want to cover a few examples of what can go wrong when there's no estate plan or when there isn't a carefully thought out estate plan. So our first example is Mr. James Dean, who died without a will at the age of 29. So dying without a will is also called dying intestate or intestacy. So his entire estate, including his licensing fees, passed to his father who had abandoned him as a child. Now, these licensing fees generated between 1 and 3 million per year, and they all went to his father after his death. Now, this is an example of what can happen when you die without a will, and the state then decides for you who gets your stuff. So, since his father had abandoned him as a child, it's probably a safe guess that he didn't intend for his father to receive his stuff. But because he died intestate, the state just decides for you where your stuff goes. So Marilyn Monroe, this is an example of what can go wrong when wishes aren't clear. So she died at the age of 36, and she left 75% to her acting coach with wishes to donate to charity. Her acting coach later married, and at death in 1982, his estate included all of her licensing fees and royalty fees, and everything went to his widow, who is a complete stranger to Marilyn Monroe, and nothing went to charity at all. So this is an example of what can go wrong when wishes are not clear. My third example is Barbara Hutton. She's one of the richest women in the world, and she became known as the poor little rich girl. She was the granddaughter of F.W. Woolworth. She received 25 million in trust at age 10. And when the trust terminated on her 21st birthday, her total net worth was around 50 million. So 46 years later and 7 husbands later, she died at the age of 66 with a mere $3,000 to her name. She experienced years of relentless exploitation, spousal abuse, drug addiction, and just outrageous, uncontrolled spending. So I put this in here because this is an example of what can go wrong when a young person comes into a ton of money at one time. So I think they can easily become the victim of predators and uncontrolled spending. Okay, so now let's talk about what your options are if you wanted to avoid some of those scenarios. So with estate planning, you're going to usually hear that you have 2 options, but really I think of it as 3 options because you always have the option to do nothing. And we'll go into what that looks like if you decide to do nothing. But with estate planning, you do have two options, and that's either the will-based plan or the living trust-based plan. And really, this is a decision that everyone has to make, right? Whether you're married or single, you have kids or don't, regardless of how much money you have to decide one of these options. You're going to do nothing, you're going to do a will, or you're going to do a trust. Almost everyone I work with chooses a trust over a will and over doing nothing. But I'm going to go over all of these options because I want everyone to understand what your choices are. So let's first talk about the risk to your family when you don't have a plan. So this is option one, where you basically do nothing. So if you do nothing, not even a will, this is also known as dying intestate, which essentially means that you're relinquishing control to the state to decide for you where your stuff goes and who will be the guardians for your children. So sometimes this is referred to as the state plan because the state basically gets to decide everything for you. So because you guys are here today learning about estate planning, this may be the situation that some of you or many of you are in. This is, again, the doing nothing scenario, and it means that you're going to end up with California's default plan. So let's talk about what that default plan is and the downsides. So if you die doing nothing, which means dying intestate, then your assets will get distributed according to state law, and it could go to people that you don't want. So you can think of the James Dean example there, where it went to his father that abandoned him. Your kids will get their inheritance at age 18 and outright. We saw how that could be lost in a divorce or spent unwisely. A spouse could remarry after your death, leaving money to a new spouse and kids. And then a judge gets to decide who raises your minor children, and a judge gets to decide who is in control of your children's money. And then a probate court proceeding is guaranteed. So these are all the things that will happen when you die doing nothing. So let's look at option two. This is a last will and testament. So having a will is always better than having nothing or doing nothing. So in a will, what happens is you name your beneficiaries for your assets. And this is just basically stating who you want your stuff to go to. And then you would name an executor, and this is the person who is in charge of wrapping up your affairs and your estate when you're gone. And they'll follow the instructions of the will. So there's some pretty big downsides to having a will that a lot of people tell me that they didn't realize. So first, wills, they do have to go through probate court at your death. And we're going to talk about probate court in just a few minutes. So even though you've chosen a executor to administer where your stuff goes and to follow the instructions of the will, it still has to all get supervised by the court in a probate proceeding. Wills are only effective at your death, so it doesn't help if you're alive but disabled or you are incapacitated and unable to manage your own affairs. Wills can also be problematic if you move to a different state to retire or to live because each state has their own laws regarding wills. So a California will might not be effective in Texas or Florida, and you may have to redo your entire estate plan. And then lastly, a will simply instructs where you want your property to go after death. So you're not going to be able to say, well, first of all, in a will, you will be able to say, I want my money to go to my daughter when I pass away. But what you won't be able to say is that she has to be 25 or that she has to have finished college. So you won't be allowed to put in any additional instructions in a will for how or when the money is spent for your children. You would need a trust to do that. So most parents I talk to don't want their kids to inherit everything when they turn 18 because that's the age that you're legally entitled to inherit money. Most parents I talk to want their kids to get it later in life when they're a little bit more mature. But in a will, There is no control that you would have to be able to put any conditions on how much they're getting or when. So for the first or second option, whether you do nothing, remember that's the first option, or you have a will, it is important to understand that probate court is guaranteed for either of those options. So your family is going to have to go to probate court before your money or assets can be distributed to your family after you pass. So there are four big downsides to probate court. It can take a long time, up to a year or more to get final approval. During this time, all of the assets will be frozen. So until the court decides on the distribution of the property, your family is not going to be able to access that money. So if your family needs that money for support, they're not going to be able to access it. Probate is expensive. It can eat between 4 to 7% of your total estate. And we're going to go through an example so you can see what that looks like. And then probate is a public process. So what that means is that anyone can pull your court filing, they can see your assets, they can see the value, and they can see who it's going to. If there's any disputes over the assets, this information is also public. So there is no expectation of privacy in a probate proceeding. So you can see then how all of these delays and costs can really add a lot of stress to a loved one during a very difficult time already. So probate court, it's basically you have to go to probate court to change the title on the property or accounts that you own when you die from you to your family. So what happens is there's a full inventory of your assets done. There's an appraisal of each asset that's done. If anyone is contesting the will, then those disputes will get settled in probate court. And then finally, the assets will get distributed to the rightful beneficiaries. So a judge oversees the entire process. You're going to need court approval or court permission to do anything while it's in probate court. Generally, your family will have to hire a lawyer because it's a complex process. Of course, they can do it on their own, but that's just never advised. So I mentioned earlier that probate fees can eat up as much as 4 to 7% of the estate assets. So these fees are going to reduce the amount of money that ultimately goes to your family. So I have this example in there so that you guys can really see how it works. So this is a sample estate of a single woman. She's created a will and she's left everything to her daughter, who is a minor. She's 10 years old, let's say. So Rebecca is her name. And so let's see Rebecca's assets. She has a family home worth $1 million in California. That's pretty typical. And then she has a rental investment property worth $500,000. She's got an investment account with stocks and bonds for $250,000. And then she has a life insurance policy of $1 million. And then she has a 401k account with about $50,000 in there. So because she has a minor daughter and minors can't inherit property, these assets now all have to go through probate court so that a judge can make sure that the money is being handled properly and they all become part of the probate estate. So when we add all of that up, the total probate estate is 2.8 million. And even if we assume that the cost is only 4% of the total estate, that's already $112,000 that gets lost in probate. And up to 7% would be $196,000. So $112,000 to $196,000 would not be going to the minor daughter. It would be going to probate fees. That's a huge chunk. I also want to point out here that the probate estate will look at the gross value of your estate. So They won't just look at the equity. There won't be a deduction for that. So for example, that family home that's worth $1 million, if that home has an $800,000 mortgage on it, there's actually only $200,000 of equity available. So when you look at it this way, you can really see how these probate fees can have the potential to quickly eat up what's actually available to go to the family. So now knowing these downsides of a will, are any of you wondering why anyone would do a will? Well, I do get asked this question all the time once people see the downsides of having a will. And there are times when a will-based plan is appropriate. So in California, if your estate is less than 184, $500,000, then you would be eligible for a simplified probate process, which is a lot easier and it's not as expensive. It's relatively inexpensive. So in that case, a will would be sufficient. If you have an estate worth more than that, though, obviously, then you would go through all the downsides that we just discussed. A will is also appropriate if a will is simply the more affordable option for you. Like I said, a will is still better than doing nothing. And then a will is also appropriate if you just don't mind that your family has to go through probate. So if probate avoidance isn't a goal, then a will is perfectly fine. And so there are, some out there that don't mind. The probate process really doesn't bother them. So let's talk about that second estate planning option, or the third option in the way that I view it. And that's something called the revocable living trust. This is the option that almost everyone that I work with chooses. And I'm going to go into more detail about why it's a much better option. But let's first start with what it even is. So a trust is really just an agreement. It spells out the rules that you want followed for the assets that are owned by the trust when you pass away. So it really does all the things that people assume are done by a will. And personally, to me, it's like a will, just much better. So a revocable living trust is where you can name beneficiaries, which is basically where you're listing the people that you want to get your stuff. It's revocable, which means that you can change or amend it at any time. You get to be the trustee during your lifetime, and this is what is going to allow you to remain in control of the trust and the document itself and the assets that go into the trust. And then the best part is that it completely bypasses probate. So there is no court proceeding that you have to go through or that your heirs have to go through in order to access the assets that are in the trust. So one common misconception I get a lot about trusts is that trusts are only for wealthy people with a lot of assets to leave behind. So I'm sure we've all heard the term trust fund baby, and many of us probably just assume that we don't fall into that category, that we're not a trust fund baby, so we must not need a trust. But I want to show you in the next example that it really doesn't matter that you aren't rich. Trusts can offer very valuable benefits and they can be a powerful tool for estate planning. So this is my example of Bob, who has $100,000 in a bank account and he wants to leave it to his son, Fred, when he dies. But he wants Fred to be 25 and he wants Fred to have finished college before he gets this money. So what Bob needs is a trust. So this is an example of Bob is not wealthy. He's not trying to set up some fancy trust because he's leaving millions behind, right? He just wants to put some rules in place. So he just wants his son to be 25 and to have graduated college. So Bob just needs a trust to carry out this intention, even though he doesn't have a lot of money or a complicated estate. He needs a trust, and the trust is what's going to allow him to keep this control over how and when his son gets his inheritance. So a lot of people will explain a trust as giving control, and it's almost as if when you passed away, you still have a hand reaching out of the grave with control over how you want your children to be able to receive their money or what kind of conditions you want to put on it. So there are three roles in every trust, and you would occupy all three positions. So the grantor is the person who's creating the trust and contributing assets into it. The trustee is basically the person who manages the trust. The beneficiary is the person who is entitled to the assets. And being in all three roles is what will keep you in control of your assets, even though those assets are titled in the name of the trust. So it's basically business as usual. All your taxes will get filed in the same way that you've always done them. The government essentially ignores the trust for tax purposes, and they'll just continue to tax you as individuals. So one way to think about a trust is like a kid's backpack. When your child starts school, they get to pick out a backpack, and it could be any kind of backpack they want, any color, size. There's always like a million options out there. So your trust is basically the same way in that you will get to design it so that it accomplishes exactly what you want it to accomplish. So the goal really is to have your trust hold your assets, because then those assets will be distributed according to the terms of the trust or that trust document when you pass away. And then when you pass away, everything that's in that backpack or in that trust, it will be able to pass to your family without probate court. So basically everything in the backpack doesn't go through probate court. Now, trust funding is simply transferring assets into the trust. It's simply changing the ownership or retitling your assets so that the trust owns them instead of you. For example, if you own property and you own them in your name right now, in your individual name, trust funding is simply transferring that home so that it is now owned by your trust, and that is who is on title. So pictured there is kind of picture just like that lady or her daughter is putting all the stuff in the backpack. That's how you fund your trust. You want to be transferring everything into the backpack or into the trust. So then a trust is really so great because it really solves all the problems that come with a will. You won't lose 4 to 7% of your estate in probate court. Your assets can go to your family in weeks, not years. And then it's totally private during life and at death. There is no publicizing it like there would be in probate court. It won't be accessible to the public. Couple other benefits. I mentioned before, it's easily changed. You can amend it. So as your life changes, you can make changes to the trust document very easily. There's not a separate tax identity number. It doesn't change your tax filing at all. It's valid in every state, so you won't have to redo your plan every time you move. And then it's not any more difficult to create or maintain a living trust than it is to create a will. Because it's a private document, no one knows what's in it, so it's more difficult to attack or contest. And again, it's the easiest way to think about it is one backpack that holds all of your property. So let's talk a little bit about guardianship nominations for those of you who have kids and you might be wondering about guardians. So if you have minor children, one of your top priorities, I'm sure, is getting in writing who you want raising your children should anything happen to you. I think parents of minor children probably need planning more than anyone, because there is nothing more important than making sure that your kids are taken care of by the people that you want, the way that you want, no matter what. So you nominate guardians through a guardianship nomination, and this can be done with a will-based plan or a trust-based plan. You can also nominate them in a will. I prefer to do it in a standalone document. That way, if there's ever any amendments that have to be made, you don't have to go in and change your will. You just change the guardianship nomination. All right, so let's step away for a moment from the will versus the trust question. So I think by now you should have all decided in your mind which option is probably best for you and your family at this point. So the second big issue that I want to talk about is some of the fears that we as parents have, right? When we're gone and we think about how we can make sure that we protect our children. So most of the parents I talk to have expressed worry that once they're gone and leave their money to their children, it will get commingled with a spouse and it's going to get lost in divorce, or they worry that their kids will lose their inheritance to creditors or lawsuits. And obviously, these are all very real possibilities if you give your kids big lump sum outright on their 18th birthday. And that's just because they don't have the experience and maturity yet to handle all of that money. So let's go through a little example that I have. This will illustrate how you can design your estate plan to protect against some of those things that we worry about. So Harry and Wendy, husband and wife, they have two young adult kids. Denise is 21 and Sam is 18. So Harry and Wendy have simple wills. They've left outright their inheritance to their kids. So in this case, Harry and Wendy are leaving behind, let's say, $2 million. And so Denise and Sam will receive $1 million each from Harry and Wendy, their parents. And this represents a lifetime of their hard-earned wealth. So Denise is married to Jason, and Jason isn't a very hard worker. He doesn't do much to support the family. So Denise gets her $1 million inheritance, and she proceeds to dump it into a joint bank account that she has with Jason. So now she's commingled the money. And when they end up getting divorced a few years later, Jason is now entitled to half of that money. So I'm sure that this is the last thing that Harry and Wendy wanted, to have worked hard all their lives only to see half of what they leave their daughter go to her ex-husband. So Sam, on the other hand, let's talk about Sam and what happens to him. He takes his $1 million and he dumps it into his checking account. So Sam isn't married, but Sam is absent-minded and he is accident prone. So he leaves the water running in his bathtub. He goes out for the night, goes partying. And what happens is the water ends up flooding the apartment below his. Well, of course, his downstairs neighbor ends up suing. And then Sam ends up losing his entire inheritance settling that lawsuit. Now, again, I don't know about you guys, but I am sure that this is the last thing that Harry and Wendy wanted, was to work hard all their lives only to see Sam lose everything in a lawsuit. So what could we do to ensure that Denise and Sam's inheritance isn't lost to divorce, lawsuits, or even bankruptcy? So the solution is something called a children's trust. I want you to think of a children's trust as a tube of toothpaste. That's really the best analogy, and it's actually a really good one. So the mistake that Harry and Wendy made is that they gave their kids outright their inheritance. So when you give outright distributions to your heirs or your kids, it is just like squeezing all of the toothpaste out of the tube and leaving it right there on the counter. So once it's out, it's almost impossible. It actually is, it's impossible to get it back in. Not almost impossible. It's impossible to get back in. The money is just out on the counter. It can now be commingled with a spouse. It can be lost to creditors. It can be spent unwisely, and there's no way to get it back into the tube. So when you have a children's trust, that trust can hold your kids' inheritance, and then money can then be squeezed out when your children need it. And everything that stays in the tube is then protected from divorce, from creditors, from lawsuits, and from bankruptcy. So if you want these kinds of protections in place, then what I recommend is setting up a children's trust along with your revocable living trust. And this is the option that almost everyone that I work with ends up choosing. They do a revocable living trust because that avoids probate. And then they also do a children's trust to protect their kids' inheritance. So what I generally see with regard to the children's trust is that they'll either choose that all of that money can go to the kids at 25. They're a little bit older than 18, a little bit more mature. I've also seen staggered distributions of 1/3 at 25, 1/3 at 30, 1/3 at 35. It's really your preference, but it does help to preserve their inheritance until they're old enough. But you really can choose whatever you would like, depending on your children and you know what you want. Okay, so we are nearing the end of the presentation, but I do want to talk about taxes. So there are a few tax consequences that happen at death that I want everyone to understand. I'm going to start with the two taxes that I see a lot of people conflate or they get confused by, and that's property taxes and capital gains tax, which are two just completely separate taxes. So if you own property in California, I'm sure you pay property tax. We all do. So it used to be that in California, you could pass property down to your children and they would be able to keep the same property tax basis. Well, Prop 19 went into effect in 2021, and that benefit has now changed. So now, in order to keep the same property tax basis, your child has to move into the home and use it as their primary residence within 1 year in order to avoid reassessment. So, just a simple example of that, let's say we purchase property, and when we purchased it, it was $100,000. And so our property tax basis is going to be based on $100,000, and it does go up every year, but it's capped. So once we pass, we used to be able to pass that property on to our children, and our children would keep that same property tax basis. So that would still be based on the $100,000. Well, now going forward, that property will get reassessed. So if that property is now worth $1 million, property taxes will now sky high, will get raised to be based on that $1 million versus the $100,000. So 1 million would be the new basis. And the way to be excluded or exempt from that is that if that child moves into that home within 1 year and uses it as their primary residence. So if they do that, then they're able to keep that same $100,000 basis. Where I see a lot of this coming into play and becoming an issue is on rental properties or other investment property, where they will get reassessed. So that's the property tax consequence. And then we've got capital gains taxes. So capital gains tax is any tax that is the tax you pay on appreciation in a property. So that's separate from the property tax. So the best way to avoid capital gains tax is to inherit property because your children will get a stepped up basis in the property, eliminating the capital gains tax on that appreciation, which can be a huge tax savings. So what I have seen many parents do because they just don't understand or they don't know, is that they deed or they gift property to their children before their death, thinking that they're giving their children a wonderful gift. Well, when you do that, it actually carries over the basis in the property to the children, and they lose that ability to get that stepped up basis. So in that same example, if the parent purchases the property for 100,000 and at their death it's appreciated to $1 million, if the child inherits the property, they will get a stepped up basis, and there is no tax due on that differential. However, if they've deeded the property to them, then that basis gets carried over so that when that child goes to sell the property, they will get they will be responsible for capital gains tax based on that original basis of $100,000 when their parent purchased the property. So I hope that makes sense. The takeaway there is it's just always better to inherit property for that stepped up basis. So the other big tax is the estate tax. Estate tax is a tax that's due when someone passes away, if they have more than a certain amount of money. So there isn't a California estate tax. I think we're one of the 38 states that don't have that, but there is a federal one that we are subject to. So if you die with more than 13,610,000, that's the exemption in 2024, then your estate will be subject to federal estate tax, and that is at a 40% rate. It's pretty high. And that if you're in this category, then you can reduce the tax liability by doing more advanced planning. That's beyond the scope of this webinar, but we can certainly talk more about that. The other thing I wanted to note about that is that amount, that exemption amount is sunsetting in 2025, end of 2025. So we don't know what that new exemption amount is. I think it's probably going to be between 5 and 7 million. But again, I'm not sure, and we don't know what that is yet, but that is coming. So that's another thing with estate planning and the taxes. You do want to be continually, once you have an estate plan in place, you still want to be continuing to at least review that plan every year to see if there's any changes that need to be made. So just from my own personal experience and working with families, I truly, truly believe that everyone should have an estate plan in place. It's just so important, and it really provides just so much peace of mind for yourself and your family. And it's such a gift to help minimize their stress. It helps protect their future. It honors their wishes and your wishes. And last but not least, it really helps to preserve legacy. So I know we're all busy with everyday life, kids, work, aging parents. I know estate planning isn't usually top of mind for people. So what I've done is really try to make estate planning as simple and possible, as simple as planning, excuse me, as simple and painless as possible by offering a completely virtual experience. I'm just going to quickly go over what my virtual planning process is. So I really try to get it all done in 2 virtual meetings if that's possible. So the first step would be to book a legacy planning consultation. And this is where we can talk about your goals and objectives and what you want to do to protect your family and assets. And then I will go over your options and then my flat fee packages. And then we can decide if we're a good fit to work together. And if we are, then we'll just continue to the next step, which would be to book a legacy design meeting. And this is really the meeting for us to get into the details and design of what you want your estate plan to look like. I then draft your estate planning documents, send them to you for review. If you have questions, we review them together, make changes to reflect your intentions. Once all of that is finalized, then you get to pick a date to sign everything. And then as part of the virtual process, You can sign in your own home. I will send a notary over. I do have an office in Orange as well. If you wanted to come into an office, that would be perfectly fine too. And then after that, we send you your little storage binder with all of the documents. You'll also get electronic documents as well, because in this day and age, it's always good to have that electronic copy. And then I promise that this is how you will feel after you complete your estate plan. It really is such a huge weight lifted off your shoulders and will be a reason to celebrate. So, as a thank you for attending today's session, if you book a consultation within the next 3 days, I would love to waive that 350 planning consultation fee, and then give you 10% off your estate planning package. So I'll just leave this here. There's a QR code if you want to scan that to book a consultation. You can also go to my website and connect there that way, and there's a link there as well. So I'd be happy to take any questions and answer or questions at this point. We can do some Q&A if anyone has questions.
Does anyone have any question? Doesn't look like. Yeah, I didn't
Yeah,
know.
I wasn't monitoring the chat, so I'm not sure if anything came in there,
No,
but
nothing came in there, looks like.
okay. Yeah, no problem.
But either ways, look, so I'll post it on the website or so. So if anyone is interested, I would say that please contact Natalie. And Natalie also has given the website address here, www.teralegacyplanning.com. And if any one of you wants to reach out to me, I also can help you to get connected with Natalie. And yeah, as she mentioned, she's giving a very good discount. Also, get that leverage. I mean, get a consultation with Natalie and then get it going. I mean, it's a very important thing. And I must say that I 100% agree with her that doesn't matter whether you're young or you're old. This is something that's required for everyone. In fact, everyone above 18 in this country needs this thing for various reasons, as she mentioned. So yeah, thank you, Natalie, for your time to this Friday evening. I know you have probably had some other family responsibilities or commitments, but you still made time to, educate us and to organize this webinar. And thanks a lot for that. I really appreciate it, Natalie.
Yeah, thank you for having me. I really enjoyed it, and I hope that everyone was able to find some value in the presentation. And again, feel free to reach out anytime if you guys had any other questions. I'm happy to help.
Sure, sure. I would have the same message to everyone.
Okay, great.
Okay, all right then. Thanks everyone again. Have a nice weekend. Bye-bye.
Bye, everyone.